Yeah, we are live. Starting.
Hello, everyone. Thank you so much for tuning into this discussion. This topic is something we consider to be very important to all of us here. We're hoping that this discussion throws light on our freedom to interact even on this very platform. And so we at Digital Dialogues, the discussion arm of the Digital Journalists Association of India, request you to participate actively by posting any question that comes to your mind as this discussion progresses. To formally welcome everyone who's joining us on this discussion on the topic, the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021, I invite a man of many avatars, one we all respect, Mr. K. Srinivasan, the founder of Digital Journalists Association of India. So the floor is yours.
Good evening, viewers. Good evening, panelists. I welcome you all for this very important discussion today evening. On 7th of April, the Government of India issued a revised guideline on intermediary and media ethics code. Immediately on the same day, some of the media organizations immediately requested for withdrawal of such guidelines, as according to them, it was violating the freedom of expression. This is one of the things that we need to have a lot of discussion or remove the myths among our own people. DiJAI, right for the past 4 or 5 years, we have been demanding the government of India and authorities that with the new advent of, with the increased technological growth like YouTube and social media, we need a proper regulation. It is not that no regulation regime is not going to help us in future, because we should understand there must be a regulation. That regulation should be it should protect the genuine people and remove the culprits or criminals. Probably I would like to recall in 2012 or so, when some people, the activists went to Supreme Court for removal of 66A of Information Technology Act. That was removed on the ground of freedom of expression. At that time itself, even Mr. NaaVi and myself, we were all active members of Cyber Society of India. At the time, even I was the president then. We gave a media statement that it was a wrong decision and in future we may be suffering a lot. Today, there is no substitute or there is no provision to safeguard the interest of the women of this country, our own sisters, our own women in our household. Genuinely, they are being affected, but there is no control. Because sometimes unknowingly, probably we jump, saying that freedom of expression is getting affected and we make a noise. But ultimately, it helps only the wrong people and not the right people. Now, that was done 10 years back. Probably at the time, we were not that much mature. Now we have gone a long way. Now we are seeing how much of a defaming, how much of a fake news is going on, how much of a misinformation and disinformation is going on. It is affecting the genuine journalists of this country, not only in this country, across the world. Now we need to, as a professional, we need to decide how the regulation should go to curb the criminals and not the genuine journalists. It should always protect the genuine journalists. So on behalf of DiJAI, we organize this so that we have invited a lot of experts, even international perspective also will be speaking. We over to Prem to carry on with that. I'll join you at a later. Thank you very much. Welcome you all for this show. Please enjoy and share your question so that experts can give an answer for that. Thank you. Welcome.
Thank you, sir, for those words. Now let's turn our attention to the panel discussion and shine the spotlight on each of the panelists who have been brought here for the very specific roles they play in the digital space. First up, Mr. Vijayashankar, or popularly known as NaaVi, specializes in the consultancy related to regulatory compliance in the areas of Information Technology Act and the Digital Personal Data Protection Act, apart from various other cyber laws related rules. NaaVi is also a registered independent director with the Ministry of Corporate Affairs, Government of India. He's a thought leader who pioneered several concepts in cyber jurisprudence in India and also introduced services including cyber evidence archival and online dispute resolution. He's also worked on path-breaking indigenously developed concepts such as Personal Data Protection Standards of India, or PDPSI, as a framework for digital privacy compliance. He's presently working actively towards a legislation on neuro rights and artificial intelligence regulation as an extension of privacy right regulation. He has nearly 50 years of domain expertise in banking, advertising, cyber law, education, information, and data security compliance. NaaVi joins us from Bengaluru. Next panelist that I'd like to shine the spotlight on is Mr. Swaminathan Iyer. For the past 24 years, Swaminathan Iyer has been a strategic digital leader in the internet and media and entertainment space across the Asia-Pacific region. He has a proven track record of success and extensive experience in various aspects of digital business, including product management, product marketing, business development, and sales growth. Throughout his career, he has worked with news, finance, sports, entertainment, OTT streaming products, social media offerings, and websites, working with leading organizations including the Times Group, Yahoo, ESPN Stars, Paramount, and Deutsche Bank. Swami joins us from Singapore. Mr. Vinoth Poovalingam, also my teammate in DiJAI, who's an honorary secretary himself. So Vinoth is the CEO of Hocalwire, a media tech company working to optimize technology for new age publishing media. Vinoth leads the business strategy and operations at Hocalwire. He started his career at Flipkart, where he was part of the core team and was involved in planning and execution of day-to-day operations. He was instrumental in launching Flipkart's own delivery network, which we now know as eCart Logistics. After he moved to Amazon, he was pivotal in the launch of Amazon transportation network in India. In his last role with Amway, he worked with various teams to enable a major overhaul of the e-commerce operations of Amway. Vinoth has worked on some big projects that have shaped the e-commerce industry in India. Now he's on a journey to help publishers understand the ever-changing media tech landscape. Vinoth is an IIM Bangalore and IIT Madras alumnus. He joins us from New Delhi. So it's a privilege to have all three of you on this panel. I am Prem Shankar, a journalist who's here to moderate this discussion and express my views, if any. In my individual capacity, I do not represent the views of Press Trust of India, the organization I work for. Let's immediately dive into the panel discussion now. May I now request you for your opening remarks. NaaVi, can you start with your opening remarks?
Yeah, good evening, friends. It's a privilege to speak to all of you. Now, we are discussing the intermediary guidelines of 7th April 2023. However, this concept of intermediary guidelines is as old as Information Technology Act, which had introduced a section called Section 79, basically to provide protection to intermediaries from being held liable for third-party information. Section 79 said that for getting this kind of protection, the intermediary needs to follow certain due diligence. And the due diligence was actually prescribed in the form of guidelines, first in the year 2011 and subsequently in 2021, February 25th, which was again replaced in October 2022, and now the latest guideline. So this is not a new thing. It has been in existence. What is new in the recent guideline is that there has been a concern for the fact check activity, so that the possibility of fake news going viral on the social media is reduced. So this is one of the important things. Mr. Srinivasan was mentioning Section 66 capital A, which was omitted from the Act because Supreme Court in the Shreya Singhal case felt that Section 66A could affect the freedom of expression because it penalized certain aspects of, say, messaging on the internet. I personally felt at that time that it was technically not a correct view of the Supreme Court, but that is for another day to discuss. But in the same Shreya Singhal judgment, Supreme Court upheld Section 79. Both the Section 79 has got three specific subsections. Subsection 1 and 2, it upheld as it is. The subsection 3, Supreme Court read down. What we mean by read down is it actually added meaning to what was there in section 79.3, because section 79 subsection 3 said that an intermediary has to remove the content which has been held as, say, offensive or illegal by an authority. Now, the Supreme Court said by authority, what we mean is a court or a competent authority of the government. So the Supreme Court said that this takedown measure, which was there in section 79 subsection 3, is also legal, provided, of course, the instructions come from a competent authority, which can be a court or a competent authority like section under section 69A, a committee of the Home Ministry, something like that. Basically, it said that if some Tom, Dick, and Harry, including the person who is an alleged affected person or victim, if he sends a notice to an intermediary need not actually take down the message or whatever is the offensive content. It has to act only when it comes from a court. So this was Shreya's single. And the latest change very recently in this 21 February guideline, the government also said that there should be a digital media ethics code. And while addressing this digital media ethics code, it also said that for resolving the disputes, we need to have a grievance appellate committee. It suggested actually self-regulatory bodies, and at the level 3 it said that after the self-regulatory body of the intermediary, and then level 2 self-regulatory body of the industry, next we will have a grievance appellate tribunal or committee. It is not a tribunal, it's a committee, which has been very recently put into action. And this October 22 guideline spoke more about the grievance appellate committee. I understand that the committee is now in existence. It works under www.gac.gov.in, where any member of the public can put up a complaint for the committee to take a decision. Committee members are supposed to be one, of course, from the government, maybe from other from the public also. So in this 7th April, the addition was that it said the central government is interested in setting up a fact check organization of its own, so that if any news about the government department or ministry is put up, and if it is false, this fact check unit will put up on a website like the PIB fact check or some other website that the government considers that this information is not correct. Now, after this kind of a calling out, it is open to the intermediary to take note of it and then remove the content on its own voluntarily. But otherwise, this is not a mandate to take down the information. But in case somebody claims some adverse impact of this news, which has been held bad, goes to the court will then ask the intermediary, you knew that this was considered fake because somebody, particularly a government-backed body, said so, but you did not take any action to remove the content. Why is it so? So at that time, the intermediary will have to justify its decision. Otherwise, it will not get the safe harbor protection under section 79. That is all the effect of this particular section 79. I think this as initial remarks is okay. We will come back to it if there are any questions and what others experts speak about it. Go ahead, Prem Shankar.
Thank you for that, sir. Swami, may I get your opening remarks, please?
Yeah, good evening, everybody. Thanks for having me on this panel. So from my perspective, I think we all know fake news generally global, from a global perspective, is detrimental to everybody, right? It causes a lot of economic harm apart from having political biases and all these things. And social media platforms have been trying to tackle not only what we call as malicious content, right? It's not only fake news, but content which is harming anybody or harming a community or harming minors and any of these things. So a lot of social platforms, and I think even in my days of Yahoo, we worked very closely with the government to ensure that we are compliant with the local laws. And I'll just enunciate certain things that social platforms do, and this is generically for everybody. The idea is that every social platform in its own right uses some form of this methodology to curb the content in its own way of self-regulation, which NaaVi sir was saying. So one is content moderation. Obviously, whatever content is posted on any social platform, they ensure that it's as per the guidelines and terms and conditions of the local company. Because if certain kind of content is not allowed in a certain country, it will ensure that content is removed or flagged. It allows users to report the system. So if I think certain content is not up to the mark or what might be the case, that content I can flag, and that content goes to a bunch of moderators who can go and look at it. If it's all okay, or if it's a copyright violation, which is the most common cause of a lot of content violation, because especially on YouTube, somebody will take somebody's music and put something up. That kind of content also needs to be curbed. Social platforms allow that reporting to happen, and they take care of it. The other thing is user education. Like, I don't know if you guys remember, but when TikTok came in India and many other markets, it was very clear that you cannot post any pornographic content on this, because we do not. And they were very clear on some of those things when they did that. Even some other platforms did that to ensure that they are in compliance with what the user should do on the platform based on the terms and conditions. The other thing which is very important and commonly done these days is account verification. So if you look at it, sometimes your Facebook gets hacked. Somebody else will post some money. They'll put up post saying, "Okay, I need money urgently. Mail me this." This is all actually also kind of fake thing that is happening with this fraud that is happening. So account verification helps in some form. So if I'm able to give my email ID or phone number in a proper way, and nobody else can hack into my system, it protects me. It also protects the overall society, because we know everybody that is posting is genuine and not, because most of the fake news that is spread or malicious content that is spread by anonymous bots or people who are not people actually. And the other thing is obviously collaboration with all law enforcement agencies. I think, like NaaVi sir said, most social platforms do comply with all the regulations and everything as far as they're possible. And if there are any illegal activity, they will report and they will help the government on these things. I think I was reading a lot of articles on this topic, and I think the challenge that the government is facing, or at least the body is facing on the journalist side, is the oversight by the government-run committee with the power to block publication and stories and remove stories and even shut down entire websites. It's something that's the debate that we need to actually look through. That's what is this amendment that is happening, because what they did in 2008 really helped intermediaries. Like, at that time we were trying to launch Flickr in India at that time, and we did have a worry that the content could be some content that is can put our directors in trouble. But with the 2008 amendment that happened, it let us, because as an intermediary, I can always notice and pull down the content, and you're not liable for it. It did help us. So from that perspective, I think, and also as social media and platforms are growing, we will have evolution of laws and legal regulations happening. Today, social media is very, very prevalent. Today, like, even from a money-making perspective on the digital front, 60-70% of all digital economy actually goes to the social media sites today. Not the publications, like smaller publications. It goes to social media because they drive most of the audience. Hence, they are the prime drivers of all this content. So even if somebody else publishes it, they are the ones who can actually spread the content. From that perspective, it's important that we debate on this change in the amendment. And it's important to have some kind of regulation for this, because social media can change a lot of things. We know how Trump won his elections with Cambridge Analytica. We know how elections in Malaysia got influenced purely because of social media to get the opposition in power. So social media has that power. So the question is, how are we using that power to ensure democracy is maintaining what it needs to maintain? So I leave it to that, and we can talk more about it. Prem, back to you.
Thank you, Swami. Vinoth, can I have your opening remarks, please?
Yeah, thanks, Prem. I think wonderful points by both the other panelists. So from my perspective, I would like to approach this more from a tech perspective. I am not an intermediary per se, but we actually run a lot of platforms. We give the technology to kind of run all the platforms, right? So I was going through all the acts. I was actually reading through the documentation and things like that. So I am not denying the fact that there should be rules and regulations. Any setup or any organization to grow, everyone should have a transparent understanding of what it does, why it does, and what are the ways in which you can go back and give feedback into the system. Right? I strongly believe that kind of a structured approach will always let anyone to grow in a very nice way, which is valuable to the entire ecosystem. But what I want to actually bring notice to this panel is essentially, how is this rules of feedback, how are these getting framed? what are the rules which are getting framed, why they are getting framed, what is the contention, and who can actually frame that those are the questions I think which we need to actually ponder upon a lot, right? So I was just a couple of going through pretty much I went to the IT Act, and then I looked at the intermediary guidelines, and then I started looking at couple of GSI. I tried using the GSE portal which came up right now, and then I kind of put together a couple of questions which I feel personally are some things which I need answers for. Probably I will make the entire panel also give me some answers for that, right? So first thing which I was looking at is, why is that a government appointed or a government authorized private body being a custodian of something like a fundamental right? Section 3(1)(b), or it says it like they are supposed to uphold the fundamental rights of a particular of the people are using that particular platform, right? So the custodian, if you see any of the fundamental writs petition, everything is always state versus someone, right? I don't want it becoming a private company versus an individual becoming a fundamental right violation in the country. That is my primary first one thing. Why is that a private authority is being done with this particular thing, right? Second thing is the formation of this GSE communities, and then with representation from the government itself, right? I was just talking just before getting to the panel also, right? The kind of intermediaries listed there, all the political parties are listed, private entities like Amazon are listed, right? Anything and everything. If you so who's an intermediary? The definition itself is very pretty vague. I am a guy who's actually managing websites. Am I an intermediary, right? What is my chances of protecting my thing? Because one of these points says if you just host, transmit, and then enable the publication of that particular thing, you get into the intermediary bracket, right? So nowadays, any particular brand has a big website, right? You take a Coke, take a any consumer brand for that sake. They have a blog, they have a website. So are they also becoming publishers and intermediaries? Because they also reach out to a lot of people. They also voice their opinion. They also voice their content. Do they come under the classification? Do they get automatically under this rule? And apparently it looks like so, because the GSE council, when they start searching for Airbnb is there, PayPal payments, Airtel payments is there, all these guys are there as part of the intermediary bodies, right? So this is something which is catching me off guard. Now the next regulation which has come out is there are supposed to be three GSE committees, right? One from MeitY, which takes care of the copyright violations, one for the home, which takes care of criminal and illegal and cybercrime kind of things, and third, which is essentially the MIB, which is supposed to actually take care of the fake content and misinformation. Now if this is the case, and especially when you have political parties in the GSE portal, what stops them from being picky about whom they address? Right? If there, and especially the volumes, look at it. There is a report which says one of the leading portals in the country gets 4.3 million requests of takedown and issues reported in a month. Let us assume, and the thing, 1% of that, right, goes one way down and then goes to this thing. Does the 3-member committee or the infrastructure there support handling those many cases? 40,000 cases, 10% if you assume, right? 40,000 cases. Do they have the capacity? And if they don't have the capacity to address that much, what will they choose? How will they prioritize? Where are these things? And it is said within 48 hours I'm supposed to remove. If I don't remove, what is the justifications the government is giving me? On under what clauses can they come and tell me to remove? Can they just give a blanket saying that I told you so, so remove? Is that how it should work? Or should they come according to a particular guidelines? Should they tell based on ABC validations I'm asking you to remove? So these are some questions which I want to actually go to this thing. And to sum up, I want to probably take one more thing. I think NaaVi sir brought up this pretty thing. Section 66, which was removed by Shreya Shingal case, and he also talked about section 79 out there, right? So section 79, if you actually go by the text, right, it actually holds the intermediary non-liable. If you go by the spirit of what is section 79, you are essentially telling that, boss, whatever you do, you are not the guy who's instigating the entire thing, right? Unless otherwise they give a provision that also, that if you actually actively involved in selecting the particular target group, if you actively involve the commission of that particular thing, then you are held liable. Otherwise, you are an intermediary, I don't care. But in the current use case, as long as I also host it or I aid in this particular process, I am also look like a guy who's actually abetting that particular thought process or whatever content is coming out. So in fact, I think section 79 and this are contrary to what they claim to each other. That's my submission. I would like to close this here and then probably want to hear the expert speak and see. I'm also a learner here. I am more from a tech side looking at this and then trying to see how tech can kind of manifest itself. So back to you, Prem.
Thank you, Vinoth. One thing is very clear: there's not going to be a dearth of questions in this discussion. A whole lot of questions you have raised, even in your initial remarks. Thanks, Vinod. So we've got all the three perspectives now laid out very clear. Let's open this forum for discussion. I'll begin with one question, NaaVi sir. Basically, we've seen a couple of mentions about the 66A being made. But you're someone who wrote the very first cyber law book on cyber law in India, I think 1999, and you have seen this evolve. Where have we started from in terms of regulations stepping in, and where have we landed in the sense of why is it that were there issues even at the preliminary stages, or is it only coming up now? If you can just trace the evolution briefly and open up the discussion for Swami and Vinoth to join.
See, initially, the law wanted to actually promote e-commerce. See, that was the basic requirement of ITA 2000. So they actually discussed about the digital signature so that you can build an authenticated email or something like that. So, and in discussing how to promote e-commerce to give legal validity to the electronic documents, legal validity to the communication, they also introduced 4 sections which were called cyber crimes at that time, ITA 2000, just 4 sections. Basically because commerce also has to be protected against crimes conducted against themselves. There was also a civil section, section 43, which said that compensation will be payable for wrongful loss. Now, in 2008, when the amendments were made, the law became more, you can say, strict as far as the cyber crimes are concerned. From 4 sections, it actually went into 20 different sections of cyber crime. So the emphasis on need for security and for curbing crimes actually came from 2008. In between 2005, immediately after what was called Bozzy.com, the government actually, the private sector complained that intermediaries are being held liable because Bozzy.com CEO was arrested. And at that time, the committee was formed, expert committee, and the recommendations of the expert committee finally became the 2008 version of the law. This committee highlighted again section 79 and gave some clarifications. As Vinoth was telling, definitely section 79 is not a penal section. It does not say if you do something like this, you will be held liable. It says that you will not be held liable for any crime committed by content, third-party content, which the intermediary hosts. But this safe harbor provision, a protection, will be available subject to the intermediary following certain guidelines. What is the guidelines? It only says that please give a notice to all the users saying that they will not do, say, copyright infringement, they will not do trademark infringement. What he said, 31A or something, is all the information which an intermediary has to give in the terms and conditions as a notice to the user, so that user is aware that he has to use the intermediary's platform responsibly. That's all. If they do that, then the responsibility shifts to the user. If he still posts some harmful content, it is for the affected person to file a judicial process for getting whatever say benefits he wants to get. As far as blocking or taking down is concerned, the authority is not section 79. The authority comes under section 69 capital A of Information Technology Act, which gives powers to a committee. There is a very huge, let's say, rules and regulations regarding section 69A, a committee which will be headed by the Ministry of Home Affairs, and a few others will actually have the power to call out a particular content and issue blocking instructions. and that instruction has to be reviewed. I think with every 6 months. So some such rules and regulations are there under Section 69A. So the blocking instructions can come only from Section 69A committee, not from anybody else. Now, this grievance committee, which has come up recently, is to enable members of public to escalate their complaint to an authority. Initially, they will go to the same intermediary and say that I want this content to be removed. If they don't act, Information Technology Act has got this section 43 where they can call the adjudicator to adjudicate and pay compensation. That is for the victim himself can claim the compensation. Now, this GAC is providing an additional, kind of a outlet. Now, so far, we saw that about 41 appeals have so far been filed on this GAC portal, out of which some 28 have been disposed of. It is possible that it may multiply hundreds of times because I think what Mr. Swaminathan or somebody was mentioning was regarding Twitter or somebody, and even Google in YouTube, they get hundreds and thousands of complaints. We don't know whether all those complaints now will start landing up in the GAC. If so, they have to see how they will be able to handle it. What they have done now is they have kept it open. This GAC is going to be a virtual organization. Tomorrow, if 100 cases come, they may suddenly call Swaminathan, Iyer, myself, or PR Point and say, we'll form a committee with you as far as these 10 cases are concerned, like that. It is not necessary that they should be appointed government kind of a persons. They may have ad hoc formulations of committees. So that is something which is a practical problem which they have to handle. I suppose I've answered one or two questions which I remember from what Vinoth said. If more questions are there, I'm willing to answer again. Okay.
Yeah, but before that, I also want to sort of widen the ambit and bring in Swami here. I mean, NaaVi sir was basically laying out what the evolution that we saw, right, from 2000 onwards, from the IT Act evolution onwards. But how have you seen this? You've worked in the Asia Pacific region. You've seen this from a global perspective. Did you see some red flags, all through the way? Did you, how have you viewed it in your experience in reaching various governments? How have you experienced these kind of regulations that have come in time and again?
I think, like I said, as the internet, social media, especially the way it's grown, and it's creating real impact everywhere in the world, and everybody is worried about fake news in some form or the other. Especially COVID created more panic with fake news than it created with actually what was happening, right? So I think every government, if you look at it, is trying to put some kind of regulation or some kind of a thing in everywhere. If you look at, starting with Australia, where they made Google and Facebook's, there's something called media bargaining code. So they actually make Google and Facebook pay all the media outlets so that the whole, true ecosystem of the real news comes out and has more money in the ecosystem. That's what they did. UK has done a similar thing for online safety, where they're putting responsibility of fake news on the intermediaries like all these guys. Singapore has a law called POFMA, which is Protection of Online Falsehoods and Manipulation Act, which they passed in 2019. It gives the government the power to order correction or removal of online content that is deemed false or misleading. But apart from this, they've also done a lot of education. So the Singapore government has done a lot of educational efforts to explain to people, because what are false news, what are the fake news also, the impact is also on elderly people whose pensions are getting robbed because you get a mail from somewhere or you see a WhatsApp message that says you do this and you'll get money. That is also a bigger worry for a lot of governments. And so a lot of governments are doing that. Even the European Union has something called Digital Services Act, where they're trying to bring transparency on political advertising. They're trying to get reports on false news, visibility on credible news, and even social platforms on their own. If you look at them, they're also trying to, if you ask Facebook, they'll tell you false news typically doesn't get a lot of credence on their algorithms. They also have some fact checking of their own they're doing. So all these countries are trying to do something or other. And obviously, China is the strictest of the lot, where anything that you print against the compliance of what the government is looking at, you'll get fined, your license will get suspended. So I think fake news generally is a global problem everywhere. How everybody is acting on it and how everybody is trying to solve for it is an important aspect to look at. And I think it's important it's a problem globally, we know that. Just every country is taking its own stance. And to be honest, India is the largest market for all social platforms. It's the largest market for YouTube. It's the largest market for Facebook, largest market for a lot of these guys in terms of pure user numbers. So it becomes important. And it's also, if you look at the spread of how media was, right? India used to be dominated by print and television for a long time. That's not the case anymore. The internet is becoming with mobile penetration and Geo and everything. It's become a very dominant medium, and it's necessary that the communication that happens in the most dominant medium has to have some kind of regulation. So from that perspective, I think it's fine. And at NaaVi sir was saying, we need to figure out how these regulations help and how are we going to curb with it. I think I hear a lot of UN Karai saying, no, it's curbing the freedom of press. It's possible it's doing it, but it's also at the same time, there are not only the press, there are other aspects of the fake news also which needs to be equally curbed, which is important such regulations come in place.
Yeah, you brought me very nicely to the next question I had in mind for Vinoth. Actually, the question of fake news and the question of setting up a fact check committee by the PIB, by the government itself, that has come time and again. That has been raised very strongly, and I think Vinoth touched upon it. But Vinoth, direct question to you: you've been dealing with the back end and setting up the infrastructure for many media establishments across the country. What is your worry?
So, I again want to reiterate that I am not against this rules and regulations not getting formed. We need to have rules and regulations. I have seen people getting like the bad end of things because of fake news, right? It is a vermin which needs to be controlled. There is absolutely no doubt in that. I am only talking about the process and the way in which this is getting implemented. That is where I think we need to put our brains together on, right? See, this whole economy world over is moving towards a very decentralized approach, right? The centralized thing about I'm the custodian of everything is going to go away soon in every walk of life, right? Talk about even see on an entirely different topic, people are talking about bitcoins and a decentralized economy where there's no centralized authority itself, right? So we are talking on that front on one side. Here we are coming and telling no, everyone is one, and still see press has evolved from that area. That archaical this thing is there is one guy, or due to the way these things were setting up, there were hardly 100 people who were calling themselves a genuine press, right? And whatever and at that time also there were fake news. People are probably not able to circulate it better, but with the advent of technology they're able to do it better, much better right now, right? So going and again fact checking some 100 people is not going to work out, right? We need to actually have the ambit bit bigger, right? Now with that comes one more thing. I actually wanted to talk one more point which is a bit contrary into this, right? Whenever there was a fake issue, like for example, previously we used to see the Hindu used to publish apologies in their thing. Whenever they misprinted something, they have to place apologies, right? And right now if someone does something, they can secretly go and remove that particular content without a trace. They can remove it from their website. In fact, ulta of what content removal should happen there, we should go and tell the guy, you cannot remove it without my knowledge. If you are calling yourself press worth your salt, you cannot just remove and modify without letting me know. We should actually have that, probably something like a wayback machine which goes and tells, no, I am holding you responsible, whatever you do I'll take you to court. That should be there, right? Instead of going and telling, no, you violated this thing. Because the life of fake news or all these things are very short lived, right? They are like the paid assassins. They are gone, they are made to make that one move, right? And after that they are happy that they have got their objective. And that's what I observed also. Most of these people are like, it's very timely on that particular time, you'll have to have an end objective. They make that halla probably an election comes around, they make that halla get their objective, and after the 1 month they have no use for that particular thing, right? In fact, what I would suggest is, okay, hold them liable. That should be recorded, documented somewhere, and then you have to tell, see, on this day, on this time, you are the person who did it. I'm going to take you to court. I think that would have been a much better approach than telling that no, you violated something, remove it down, right? They'll be more than happy to tell. 48 hours is more than sufficient for you to do the damage, whatever it requires, right? So purely from a tech perspective, the way I see it, right, this thing should become decentralized. It cannot be one person coming and telling that I am the guy who's going to hold everyone responsible, right? It should be the thing. Even see, if you look at the Constitution of India, newspaper comes under the concurrent list. It doesn't come under the central list or the state list, right? That itself says we need to have a decentralized authority on this. Both the states and the central can make laws on top of this, right? and we are trying to somehow arm twist and tell no, everything goes to one guy, and then one guy will decide what the entire land should listen to. That shouldn't be the case. We should have a decentralized approach to this, and decentralized to the way that there should be incentive for that also, right? Not anyone. I have seen lot of good friends organizations who literally fight to the teeth and tell that this is fake, you have to remove it, right? I have been, after probably becoming what I am today, I am like, whenever I go into a WhatsApp chat of my family, I will be like, you are the guy who's doing this. This uncle is wrong. You cannot do this, right? Now, for that, the answer is not removing that. Answer is trying to educate. I think Swami also told very correctly. Answer is about educating people that this is how it is wrong and holding them liable. Boss, you have done this, you have to change. Yeah,
But
over to you.
These things, yeah, these things, these points. I mean, I'll just take it to NaaVi. So these points that you're mentioning that try and decentralize it. At some point, for example, all of us spoke about 66A and what were the consequences of its removal. At some point, that 66A was again brought in by the authority, right? So NaaVi, sir, you can come in the sense that it took a centralized approach to eventually put it out there for being contested, right? Isn't that how it works?
No. Section 66A, which has now been removed, what it said was that if somebody sends a communication, which means an SMS or an email to another person, and that causes a threat or annoyance with the recipient, then the recipient can take it as a criminal offense and go to the police or whatever is law enforcement, and that is punishable with a 3 years imprisonment. In fact, Section 66A was not about publishing on a website. This was where I differed with the Supreme Court ruling, because they combined cases which was there on Twitter, Karthik Chidambaram's case, this Palgar girl's case, which was Facebook. Now, there is a publishing. This was all publishing. Information Technology Act said publishing in obscene information is an offense. Information Technology Act 2000 version never said publishing is in any way offense. In fact, if you go back, ITA 2000 only held publishing of obscene information a punishable offense with 5 years imprisonment, initially 3 years and 5 years. But it said that if somebody sends an annoying message, that will come under Section 66 capital A, which is a 2008 version, okay, 2008 section. Now, Supreme Court confused this email abusers or SMS abusers on which the recipient has no support from anybody. It is like a girl getting an SMS every day morning from somebody who says, I love you, I love you. It is not an offensive message per se, but it causes annoyance to the person to the extent that that girl may even commit suicide. To address such situations, Section 66 capital A has stated that anybody who causes annoyance or issues a threat through a communication medium is punishable with 3 years. Somehow Supreme Court was misled to believing that it should be applied to Facebook, it should be applied to Twitter, it should be applied to websites, and therefore it became an issue of freedom of expression. See, freedom of expression comes in a website where you put up your information and several people are viewing it. Whereas this abuse through email comes when I send a mail only to one particular person. So it's a one-to-one communication. So this was a misconception of Section 66 capital A. But it stands now. It has been removed. Government at that time said that we will bring a replacement. It never came. Now what we are discussing is the responsibility of the intermediary. Now, intermediaries are very important cogs in the wheel of cyber crime control. You cannot control any cyber crime if there is no cooperation of the intermediaries, because they maintain the log records, they maintain the identity of the person who opens a Proton Mail account. Now, if Proton Mail is not going to tell me who is the person who has sent a threat, a terrorist message, law enforcement, even if it is Interpol or FBI, they can do nothing. So the law everywhere said that intermediaries need to cooperate with the law enforcement subject to the requirement. It doesn't say that whenever a government person wants to, for example, question his political opponent, intermediary should help or something like that. The second point which Vinoth was telling about whether there is a centralization of this. if you look at this latest guideline, it only says on behalf of government ministries, this government fact-checking unit will issue clarifications. It only represents the government ministries. So it is something which the government has to have somebody to speak out, and they said information and broadcasting ministry or this PIB will do that. It never says that we will be the sole fact check organization for all private sector things. In fact, if you look at PIB fact check Twitter, it is a crowdsourcing which they are trying to do. Anybody who knows that something is not correct, they can write to them and they will put it up in the Twitter, this thing. They are not going to do anything more. But others can see that this is something which has been called out. You know that many TVs are actually running programs on fact check itself. They say this was something which was published somewhere, this is not correct. So they're actually trying to ensure that proper information, truthful information goes to the market. Though of course there is a delay, as Vinoth was telling, most of the things get viral and one day this whatever we call as a shoot and scoot or something like that, they will get their things done, and subsequently liabilities have to be fixed. I agree with him that removal is not the solution. In fact, if you go through NaaVi.org, there was one case of copyright infringement which I received because I had allowed a guest post on my site, and that guest post was actually a copyright infringement. So another student who wrote to me saying that, what is that, sir? You have put up an article which is my copyright, and you please remove it. I would have happily removed it, but I told that particular person that instead of removing it, I will retain that with a note that this has been flagged as a copyright violation by XYZ. In fact, that is more damaging to the person who actually committed copyright, because everybody who sees that will know that this author actually has committed a copyright violation. And I told this particular complainant that I will retain this with this note. You please take that, and if you want to take any legal action, say that NaaVi has acknowledged that and use that. If I remove it, that matter ends there, and there is no evidence for further listing. So I agree with Vinoth, and that is what I have suggested. In fact, in one of the latest article, I made a mention about an Ireland media house which has started a fact check in 2016. I had suggested a system in the year 2000, December 2000, of how to handle rogue websites. This Ireland has done the same thing. What they have done is, this is a newspaper website. It is not a government of Ireland. They are running this fact check, and when they publish something, the intermediary will take it in the right spirit, and they understand that what they had put up was with some mistaken news item. They correct it and they report to the same fact check website so that we have corrected the mistake. And this fact check website again writes there that on such and such a day we had pointed out that there was an error in this thing. Now we have received confirmation. This is like the rejoinder you are talking of. The publication has told that they have corrected it. The corrected version has been given somewhere here. So that is how the news has to be filtered. See, between totally false news and real news, there are a lot of gray areas which are opinions, and something may be appearing to be false, but what happens is editors sometimes put catchy headlines. In fact, headlines create more damage than the content. Content will not be defamatory, but the headline is defamatory. Okay.
I think Prem can shed some light on that, sir.
Sometimes we are trained to do that, but the question is, who is going to decide whether it's damaging or not? That is the problem here now. Who is going to say that?
Only the victim. Yeah. Only the victim. I'm not going to decide. Let us say XYZ has put up an article. It is, let us say, against Vinoth. I am not going to call it out that it is defamatory to Vinoth. Vinoth has to take it up. But okay, and this grievance committee will help him in filing a complaint there if it is possible. Yeah,
so I have one point in this, right? See, section 3(1)(b)(5), right? Here, the exact words used is deceives or misleads address, misinformation or information which is patently false and untrue.
correct.
Right? And identified as fake or false by the fact check unit of Press Bureau of the Ministry
Okay.
of Information
Now, please
Broadcasting,
read this. Please
or
read. Yeah, please read
or
this.
other
Okay.
agency authorized by the central government for fact checking.
Yeah, that
Yeah.
is, they have enabled themselves to have more such organizations. That's all. See, you should
No,
read
no.
this.
My,
No,
so
no,
my
please, one
counter
minute, one
question
minute.
is,
One
yes,
minute. Please read this paragraph with the headline of the particular section. Headline says that the due diligence requirement is that the intermediary has to state this in the terms of conditions, telling the user not to put up deceiving information.
I
Okay.
understand, sir. No, my point is, now what I feel is this kind of empowers that the seal capacity is with the central government. If I tell you are not a fact checking guy, you are not. So this is telling authorized by the government. So the authority that why should I get the authority of government to tell if someone is lying? Why should I get the authority from government to tell someone is lying?
That I think is meant basically for representing the government views on ministry's information. Okay, because that is what the government is interested, saying that in their, for example, I have given one example which has come in PIB about Telangana Times putting up a report about some textile ministry has not included Telangana in some scheme or something like that. Now the fact check says no, that is not correct, because that fact check would have come from the textile ministry. They would have said that this news report is wrong in the sense it could have been a mistaken impression also, that there is no such move to exclude Telangana for the particular scheme or something like that. So anything which a government, department has to respond, that is what this government fact check unit will do. Otherwise, you have got somebody like Alt News, which has been in the news, that Zubair, so this thing. There are 20, 30 other things. In Tamil Nadu, there is something called U-turn. So there are many other individuals who have actually started calling out this. In fact, NaaVi.org itself has done it several times, not called it as a fact check unit, but whenever we have found a website with a phishing name, for example, I have called out a phishing website and say this is a website which is perhaps a fraud. And 3 years later, it was actually proved. So there are several such things. I have not called myself fact check unit. I observed something which I think is a crime. I have put it in my blog because I am free to put it in the blog. But I also expose myself to the risk of that person filing a case against me for defamation.
Just a hypothetical scenario, something like a Hindenburg report, right? When it came,
Yeah.
right? Like Adani outright told that everything is false, right?
Yes. Yes.
Still, they have not given lot of information saying that whatever they have called in the report, not everything has been proved from the Adani group side, right? So there is altercations. Now, in this particular scenario, Adani goes to an appellate committee and says this is wrong because they haven't revealed it yet, right? And there's no investigation yet on that, right? And they go and tell this is patently wrong, this is a false information, I don't know how they got it, right? And this is getting approved, right? Someone can go and tell the person to no, take down the entire report, you cannot do this because I have found a fact check, because investigation is not done, and I
Okay.
can give an authority because it safeguards someone interest.
Yeah.
No, won't there be a that's the question, sir. Like,
No,
won't
no.
there be a partial play kind of a thing?
Now Adani Group has gone to the court in USA and taken this up. Okay, it is court which has to go through the trial and do the investigation. Fact check unit like PIB is not having an investigating arm to do this. At best, that is where I said between totally false and true, there are a lot of gray areas, and in those areas, they may only say,
So my point is
somebody
this, right?
yeah.
So I'm exactly coming to your point, sir. Now this is coming to the point that court is supposed to do this, right?
Correct.
Now here, if you see, intermediary guidelines says within 72 hours of this notification coming from the body, they have to take it down,
No,
right?
not from the body. It has to
From
come
the
either from a court or from Section 69A committee. That Section 69A committee has got a legal force. That's
yeah,
not
that's
a
what.
fact.
So CAG
That,
will also
that,
be a legal force,
But
right?
how is the 69A comprised of? So, I mean,
no,
it comprises.
69A says that the government can have a committee
Yes, sir.
headed by the Minister Secretary of Home Affairs. It will act on the basis of complaints received from some specific persons, and after a brief inquiry, it will actually give its views as a committee, and that will be reviewed once in 2 months. That is when they issue a takedown notice. It is not permanent. So it's only effective for 2 months. Then it has to be reviewed. So there is a process there. There is a process for Section 69A committee, which is headed by the Ministry of Home Affairs Secretary, and he will have a few other interministerial persons. He may consult the DGP of a particular state and do the inquiry. So there is a process in Section 69A committee issuing a blocking information. This kind of blocking information is temporary. That is pending further inquiry or something like that. If nothing comes forth after 2 months, the intermediary can repost the same thing that we had taken it down, and now 2 months we have not received any review, so we are putting it back.
Sir,
Swami, I just want to get a perspective from Swami here, in the sense that
one last
yeah,
point.
sorry, go ahead, Vinoth. Yeah.
Sir, the reason why I was prompting this particular question is, again, when I was talking about this thing, right? So wouldn't it have been better, instead of blocking and removing the content, tell the person like what you did with the copyright? That is how it should have been handled. Instead of when someone comes and tells this blatantly false, keep it there and put a message saying this
I
is.
agree. I agree, and this was being done by FBI. I remember I told Mr. Srinivasan also, I have seen FBI for phishing sites putting a chapa. If you open that phishing site, it says this has been recognized by FBI as a phishing website. I don't know whether that system continues even now. I had observed this about 10-15 years back, and a person who had created the phishing website, he went back to his website, and suddenly when he saw this, he got so unnerved that FBI has spotted him, and that was how he came to me and say, what shall I do, or something like that. So it was there. Now, whether the same thing can be done here is a question which can be considered, because that will limit the damage. In fact, this is what I suggested in the year 2000. Remember, we are in 2023. 8th December 2000, I wrote an article, links of which are available in my latest articles. At that time, there was a Tamil-based website called dalitstone.org, which was creating havoc. It used to write anything about India, whether it's a Dalit this issue, whether it is Ramayana issue, whether it is Tamil LTT issue. If they will write post anything which is against India. Okay, that was a group. I don't know who was that group, and police were wondering what to do with this kind of a thing. At that time, social media was not there. This was only a website. At that time, I suggested that in such content, you should give a link on which counter views are posted by another 100 persons. So one damaging information is there, let it remain there, but there's 10 other people, including major, say, respectable journalists, can say why they think this is wrong. So that a reader who looks at this false information immediately recognizes there are 10 other people who are saying this is wrong. So he is not going to be misled by that wrong news. He will be perhaps going by the positive news. So this was my suggestion, but I don't know whether it can be done even now. I think this Ireland procedure is more or less similar to that, and maybe Indian government also may think about that.
So I just wanted to bring in Swami here, in the sense that, you know, the notice and takedown kind of approach that has been there earlier also, and what is going to happen now is there is going to be, if it is related to the government, then there is going to be a PIB appointed fact check committee that is going to suggest if it's fake news or false news or patently false news. So from your experience of dealing with these takedown notices, I mean, how do you view this development, in the sense that do you think that it's going to complicate things further, or as an intermediary, having spent your time on that side of the fence, how do you look at it?
No, I think when the 2008 notice and takedown came in, it was a big relief for all the intermediaries, because we were obviously following a lot of government laws and regulations, and we had put a lot of self-checks and everything. Like, we had community products, and I think this happens more likely with user-generated products, because people can come and post anything, which is what the freedom of speech is all about, right? And I think sometimes you have content which is not in compliant with a lot of laws and everything, and this helped us as an intermediary for us to say, okay, boss, I'm not liable for it, because especially the Bazi case Mr. NaaVi talked about was a very important one that actually prompted us not to launch anything that can create anything like this at that time in India. But the 2008 definitely helped intermediaries to be more free, free to do things. And I think the good thing about this 2003, 2000, the latest regulation also is they're bringing the gaming intermediaries into the picture as part of this regulation, which is also important aspect to think about. Because if you look at a lot of money resides on gaming these days in India, especially given the easy payments and online things becoming much more easier than when you used to have to figure out a credit card, which 1% of the Indian population had, which has changed with all the way digital payments are being made. So bringing in gaming payments, which can also intermediaries into this to ensure that real money and gambling doesn't happen, is also a good thing. So I think evolution of these regulations will happen and they'll keep happening. And I think we'll have to see what is right, what is wrong, and keep debating about it as the society goes ahead with it. But this will keep evolving. Like ChatGPT is the other important aspect to look at. Does it copyright? Does it have a copyright violation because it goes and goes and grabs 50,000 websites and gives you like a content in 3,000 words? Is it a copyright violation of those 3,000 books which we didn't read at all, right? So from that perspective, I think it's an evolution, and I think a lot of countries are already banning it, saying it's violating copyright. So this will evolve. I think all these regulations, yes, it's good for debate, and we should keep having these debates to say what's the next thing that we can do with this evolution. But it's an ongoing thing. I don't think this is the answer to it. It'll keep evolving. There'll be some amendments to these or some changes based on what cases happen. I think that's an important thing to look at.
Interesting. So we've got a lot of audience questions, which is very interesting. I'll quickly take one from Maithili Mahadevan, who's asking, what is the one piece of advice you would give to end users of content if we find information shared is fake or ethically wrong? I think I would club it with another question, which is, what is the role of civil society in curbing fake news and fact-checking? NaaVi, sir, you want to take it?
Yeah, so this is what I say, crowdsourcing of right information has to be encouraged. So like we put comments below the article, no, we may say that we don't consider about this thing to be correct. That should continue. Now, or the content owner or the person who has hosted should ensure that these counter opinions are given some kind of a visibility. See, today we see as I told you, we see the headline. Sometimes we don't read the content at all. We take our message from the headline. Then if we read the message, then we don't look at this content. So the content, distributor should take some responsibility in ensuring that the counter view, particularly if it comes to the calling of the content as fake or false, it should get visibility. That's all I'm trying to say. Okay, like a pop-up or something of that nature. So it should not be missed by the person. Then it is perhaps the possibility of these things called out is better. Okay.
I think Twitter was doing that for Donald Trump's tweets at some point before he got banned. I think they were putting some of the... So it's like a tag to say this news is not authentic or this news is false. I think that user notification in some form where if X number of people flag this news, it should definitely show up in some form to say, please read this with caution, or this is not something that you should consume to say it's a fact.
You can have a meter.
Giving
You can have a meter saying so many people have a percentage of people say this is incorrect. So many people say it is correct. This likes and dislikes are one way, but it doesn't say fake or true kind of a thing. Like it's different. Even a fake this thing I may like because it is very creatively expressed. Yeah.
So from my experience, what I find is mostly we encounter fake news mostly in this WhatsApp groups. That is one area which is in my own experience. Since I have been dealing with lot with news, I keep reading lot of content out, right? But typically for a person who's not so well versed with this thing or in a normal lifestyle, they generally get content pushed to them through WhatsApps and Facebooks of the world, right? So first point of action, whenever you feel that something is there, all you have to do is go and search for that particular image. You do a Google reverse image search, or you go and do a search directly. And now that with the advent of this Google schemas in place, right, immediately you will probably get a hit saying this particular content is false. You can immediately forward that back to the group saying that, see, this is what I searched and this is what it's a fact check from Google. Most of these, at least all the entities whom I am working with, like Boom Live, We are going to sign up with U-Turn also soon, probably. All these folks, they have the correct schema in place. Immediately when you dive in Google, the metadata itself tells that the content is wrong. That is first
Correct.
thing. The
Correct.
second thing what we can do is, there can be like what Chat GPT is. That's just a bot in a channel, right? If you actually go to a channel like Telegram, right, you can actually have an active bot looking at cross verifying content. If you have access to that particular bot in the thing, it can actually read through content, and it can suggest what the meter suggestion which NaaVi sir is giving. We can actually automate this in all those kind of forums where news are getting pushed. Like for example, a Facebook can have a bot which automatically cross verifies and this is the relevant thing which I bought found. Or communications can be cross verified almost on real time if you have a bot also looking at that particular communication. So I
Yes.
think this kind of but the onus I think falls completely on the like caveat emptor. That thing completely applies here also. The person who's hearing that news should be well aware of these things, and that will only come through constant education, like what Swami was telling when he started also. Government entity should start doing this fact check pretty seriously. There should be courses, or probably journalists should be going out there in the field and educating audience that this is learn to differentiate between fake news and good content. Yeah, that's my 2 cents, Prem.
Yeah, interesting. So I think all of us sort of concur on this one point that there must be more discussion on this thing. So I mean, if any of you who want to make a closing points here, we will go to that and then we'll wind up. Yes, go ahead now.
Say currently somebody has gone to the Bombay court or something like that, saying that this particular notification is unconstitutional. What I advise is, let the government come up with some say decisions. If that decision is wrong, we have to go to the court to say that the government is taking wrong decisions with wrong fact check, biased fact check. So the intervention of the court comes on the action taken by the government based on this notification. So rather than killing the notification at this time and not allowing it to improve, I think we should wait and see what the government does in 1 or 2 cases or 10 cases. Now this 40 cases of appeals, I would like to see what were those cases. In fact, I didn't get that information. I would, as a journalist, somebody can check which are these 40 cases, what was the complaint, what was how it was disposed. 28 has been disposed, what has been disposed. Then we can argue whether they are doing it correctly or not. And if that is wrong consistently, then we should go to the court to say that mechanism needs improvement, not this need for fact check, but the way fact check is being addressed by the government needs to be addressed. That is what is should be taken for judicial review, rather than jumping up and say don't have this particular notification at all. That is my view.
In a way, I also concur a lot with what NaaVi sir has just mentioned, right? See, I am not against this whole concept of rules itself not existing, right? I think this first thing someone should take, that this is the first step in that path. I think what this has done is that first step in that path. But maybe it is the right thing, not thing. That is something which needs to be debated, right? From my side, what I would probably tell is one thing which the government should look at and probably course correct really fast is trying to make sure that from a decentralized kind of approach, empowering lot more organizations in the process, and there should be an elimination of that one central authority, right? So that should be something which I would actually suggest. The second thing is what NaaVi just knows, and I was wanting to bring this point a lot more. There should be complete transparency on all these contents which is getting filed. There shouldn't be no behind the code seal cover kind of thing on this. If something goes up in this particular kind of a claim, that should be out for review for the entire world, right? It cannot be that I personally felt that this is wrong, so you take it on. So it should be enumerated, reasons given, and that should be documented for the public to see very transparently. All those 28 cases, what happened, why it happened, and how it happened, that should be documented and should be there for the entire, it should be an open book for the entire world to see. I think this kind of transparency and then getting more people into the process will definitely help in taking this forward in a very nice way, and it will help this make the society a better place to live in.
Swami, you're
I
closing
think just to conclude from my end, to summarize from my end, I think it's important that we should let the law evolve and see where it goes, because we are also learning as it goes, because as the technology evolves, 10 years ago, nobody would have figured out what is fake news. Nobody knew what fake news was. So this is a thing that evolves. Technology will evolve, society will evolve, and I think we have to let the evolution happen in its own way. But I think the important aspect is to do user education on some of these things that will harm them. It's very important. I think every government is trying to do that, because when we look at fake news from a fact-checking perspective, there's one aspect of it. The other aspect, like I said, a lot of financial and economic losses that happen because of these news, and also creates unnecessary societal tensions which should not happen. Those things are also important to curb in some form. So I think we should look at it from a holistic perspective, let it evolve, and I think I'm sure as a democracy we will also figure out what the next steps are, and we can do checks and balances to ensure that everything works in a smooth way.
Thank you so much, Swami. Thank you, NaaVi. So thank you, Vinoth. So this was a really interesting discussion, but like all of you are saying, it has to evolve. I think this evolution has to be guided by discussions. It has to be sort of taken forward with by involving, like Vinoth stressed, in a very transparent way, involving all stakeholders, be it the civil society, be it experts, legal experts, but also very, very importantly, bringing forums like us into the picture, like the Digital Journalists Association of India, which has a sort of, a very good cohesion of people who want to see a constructive change rather than take things in a very destructive manner. So looking forward to many more such discussions. Thank you to each one of you, the panelists. Thank you to the audience who actively participated. One request to the audience who joined us probably newly is to subscribe to the Digital Journalists Association of India's YouTube link. We are going to keep these discussions on. It is going to be with interesting panelists like this. So please do join us when we keep these discussions open. And so until we meet next time, thank you. Thank you all.
Thank you.